Good afternoon, everybody, and welcome to Essential Estate Planning Updates. I'm Barry Chase, the CLE Director at NYCLA. I want to thank Henry Montag for putting together this program. We've done a lot of programs together, and I appreciate all his hard work, and I'd like to thank all of our speakers. Henry Montag, who I mentioned before, is an independent certified financial planner in practice in Long Island in New York since 1984. He's the managing director of the Tolley Center East, a firm that evaluates individually owned as well as trust-owned life insurance. He has written well over 100 professional articles and given numerous CLE programs on the subject. He recently co-authored a flagship book published by the American Bar Association titled The Advisors and Trustees Guide to Managing Risks.
Well, you are in for a treat because Henry is going to talk about stuff that planners are not really paying attention to when it comes to life insurance, especially life insurance held in trust, and the different pitfalls you have from a fiduciary duty perspective. So Henry, take it away from here.
Hey, thanks very much. Okay, first off, thanks, Matt. Thanks, Cy. Great information. Every time I listen to you guys, I always learn something, which is really hard, not easy to follow. I'd also like to thank Barry Chase and NYCLA for putting the program together, and also for the opportunity to provide an executive summary regarding a book that I co-authored for the American Bar Association titled The Living Benefits of Life Insurance, and the Advisors and Trustees Guide to Managing Risk. So getting into the agenda, we're going to be talking about several things, four things primarily. One is life insurance has a death benefit, as everyone's familiar with, but it also has a living benefit, which very few people are familiar with. Secondly, the majority of life insurance in force today, approximately 50-55%, is of the non-guaranteed nature called universal life. Most people are not familiar with this, and it's a huge problem because according to industry statistics, anywhere from 55 to 60% of existing life insurance coverage is expected to expire before the insured does. We're going to be talking about the death benefit beneficiaries with some case studies, talking about the Secure Act, talking about increased estate taxes, and finally we're going to be talking about life insurance as a living benefit and how it could benefit not just the beneficiaries, but how it can also benefit the insured themselves. So life insurance is an asset class. There are different types of policies for guarantees. There are different types of policies for accumulation. There are different types of policies for maximum death benefit. There's no such thing as a bad policy. It's only a misused and mismanaged policy that causes a problem. So first thing we're going to be talking of is, why does non-guaranteed life insurance expire? Why is it a problem? Well, prior to 1980, whole life insurance and term made up 100% of the marketplace. And then all of a sudden along comes non-guaranteed universal in the early 1980s. And within a matter of literally within a matter of 18 months, because interest rates were so significantly much higher than the 3% in whole life policies, that people began using non-guaranteed interest rates. But when interest rates go down, the interest crediting rates and the paid in the policy go down as well. And all of a sudden, the premiums that the insured receives are the same, the death benefit is the same, but the only variable is the duration, and the duration of those policies, non-guaranteed policies, has significantly been shortened. The owner trustees should have increased the premium. They considered the policies as a buy and hold asset rather than a buy and manage asset because they didn't know that they should have increased the premiums. So as a result, as I mentioned, 55 to 60% of existing universal lives are expected to expire before the insured. Let's take a look at a quick case study. Male age 55 in 1991 buys $1 million. Interest rates were upwards of 12, 13%. The insured was asked, what interest rate should we use to project? He said, let's use 10, 12%. They settled on a 9% figure. So the cost for $1 million to age 95, I did not say guaranteed to age 95, but to 95 is $14,000. And then the first thing the agent would say is, well, to avoid the estate taxes, let's go ahead and have that policy owned by a trust. Who should be the trustee? Well, my oldest son and daughter, who, by the way, are basically make up more than 90% of the existing trustees. Think people that I call the amateur trustee or the unskilled trustee. There's no mention made of any sort of rate guarantees, nor the duration of coverage period, changing interest rates, no talk about ongoing active management, trustee qualifications out the window, specialized knowledge and skills, no conversation, and certainly nothing about the ongoing responsibilities and the personal fiduciary liabilities of that trustee. So what happens 30 years down the road? Well, that 8 to 9% interest rate was not achieved. It was actually closer to 4.1%. Currently, that $14,000 premium will expire later this year at the client's age 86. Client's in good shape, good health. The premium needed today to cover that policy to age 95 goes from $14,000 to $26,000. At the current premium, $14,000, that will only provide for $450,000 of life insurance to age 95 at the current rate. That was not a guaranteed rate. Again, this is the result of a buy and hold rather than a buy and manage philosophy. Non-guaranteed universal life insurance, it's a good flexible product, but it doesn't come with any type of automatic self-management. What does the Wall Street Journal say about this? Well, very simply, Wall Street Journal says that many people are in this situation. And as a matter of fact, they were one of the 3 endorsers in the book, just noting that it's a significant problem. What does the insurance industry itself say about it? Well, for the most part, they've stayed silent. However, Donald Walters, general counsel for the Insurance Marketing Standards Association, did say, quote, while insurers haven't publicized the issue, there is a growing concern of the industry about lapsing universal life policies. Can the insurance company do more for the consumer? Could they have done more for the consumer? Well, this is page 4 of a 8-page annual statement. And if you notice all the way in the bottom, under important notice, and then even in smaller font, they tell you that if you happen to read it, that changes in interest rates may affect the duration of the policy. My observations, could the insurance company have done a better job communicating? Absolutely. Should agents have been directed to service better and to provide that type of significant information to their clients? Absolutely. New compensation agreements, in my opinion, should be arranged where the agent doesn't receive all of their money up front, but that it be spread out over the period of perhaps a 5, 7, 10-year period to allow the agent to have skin in the game and to have that agent be more obligated toward providing service for the client. And incidentally, insurers benefit when policies expire prematurely to the extent of 9 to 11%. So again, attributes of trust-owned life insurance, it's a great instrument, but provides creditor protection, sophisticated financial instrument, ideally suited. Life insurance is ideally suited for trust ownership, but as I mentioned, life insurance policies aren't self-managing, and inadequately funded life policies can and do lapse. So the length of the duration of a policy really depends on the advisor's role. And here we have the insurance agent, the CPA, the attorney, the private trustee, as well as the institutional trustee. The attorney does a great job of gathering all the relevant data, reviews the client intentions, discusses who the beneficiary, the trustee should be, discusses administrative primary provisions, and even touches on the trustee's role in the duties. However, what's not discussed is the fact that life insurance has to be actively managed, needs to be monitored and reviewed, that the life insurance policy's future premiums should be watched like a hawk, and again, that the trustee has personal fiduciary liability if sued. The CPA, on the other hand, confirms the life insurance is required, confirms the current available cash flow is available, prepares the current provisions, and files the gift tax returns. But again, life insurance is left out in the cold. The private trustee, well, they're in a different world because they are guided by the by what I call running by the seat of your pants. They sign as the owner, but they basically receive no guidance. The policies are often filed away. They're unaware of their monitoring responsibilities. They're unaware of their fiduciary liabilities. They don't have the skills to perform any sort of risk assessments. They just aren't in the best of, they're just not doing what they can be doing simply because they don't have the knowledge and there's no one available to guide them. And all of the above reduces the duration of coverage And it's the unskilled, the amateur trustees, as I say, that makes up 90% of all trustees. Good news and bad news. Good news is it's an honor, it's a statement of trust. It's an opportunity to manage all of the family's trust assets. But the bad news is, again, the fact that they are held to a higher standard, and there are more and more cases coming up where state litigation from inactivity on the part of the trustee, as far as the life insurance is concerned, has really become a problem, leading to many more lawsuits. Now, the institutional trustee, they're managed by the OCC, the Office of the Controller of the Currency, and they do annually monitor the policies. They do fulfill their fiduciary liabilities and duties in managing the trust-owned life insurance. They're interested in minimizing their liability, and they don't want to damage their firm's reputation. They're familiar with the relevant responsibilities, and unfortunately, the corporate and institutional trustees only make up roughly 10% of all the trustees out there, perhaps because they do charge fees for their fiduciary services. And if they're not familiar with what needs to be done, they contract for all necessary skills. Why is the life insurance audit needed? To prevent this type of a situation. How is this matter handled in your office? A client comes in with a letter that they just received from the insurance company. Unless their $2.1 million death benefit, unless the premium is increased, the policy will lapse next year. The insured is currently 82 and in average health. Currently, he's paying $29,000, but it's now insufficient. The increase to get that policy to age 90 is $38,000 is needed to be able to keep that policy guaranteed. And by the way, the individual has to date paid approximately $580,000 in premium. What do you do with that client? How do you advise him? Well, you should have a resource in mind, because those situations can and do and will increasingly come up. If there's a problem with the policy, have the client obtain an annual summary statement as well as a historic projection, and engage an independent broker to evaluate where that policy is. 4 or 5 basic options. One can reduce the face amount. 2, one can choose to pay a higher premium. 3, if they're healthy enough and if it economically feasibly makes sense, they can obtain a new guaranteed contract if they're qualified, or they can sell the policy as a life settlement to an institutional investor, or they could do some combination of the above. As I mentioned, the 5 questions that a trustee should ask in my office is broken down into these 4 components. One is the Uniform Prudent Investment Act, and it states, bottom line, life insurance must be treated like any other asset. You look at your stocks, you look at your bonds, you look at your real estate portfolio. You can't just put that life insurance policy in the bottom left-hand drawer and forget about it. 2, the investment policy statement. What's the guidance? Not just from 10, 15, 20 years ago, but what's the updated specific beneficiaries needs today? What type of guidance does the grantor receive from the attorney or from the insured? Now, an insurance performance evaluation, life insurance companies do go under certain financial and fiscal changes. Ratings change, policy performance, the history of the cost of insurances change, dividends, which are not guaranteed, they change. An adequate funding statement, well, here's the ideal role for the accountant rather, making certain that there's sufficient premium to guarantee that the policy is adequately funded to a specific desired age. Again, that could be set to age 90, 92, 95, and also provides documentation to the trustee, providing help in the event of a future lawsuit. When proper care is taken, the benefits do accrue. And when it's done correctly, here's an outcome of just 1 or 2 situations. Individual purchased policy, gave up smoking, paid a premium of $24,000, the guaranteed death benefit was to age 84. Well, when we did the review, we realized that he had stopped smoking and in 2013, and in 2020, we were able to renegotiate the premium and the death benefit. So for the same life insurance death benefit, we were able to reduce that premium by approximately $4,000, and we're also more significantly able to increase the guaranteed age from 84 to more realistic age 90. Here's an interesting situation where husband and wife wanted to provide maximum death benefit to their grandchildren. I asked them, do you have any interest in the accumulation of the policy? No, just want the maximum death benefit. I then take a look at the policy and I find out that they have a second to die policy, which was good, the right type of policy, but it was a whole life policy. And what we know about whole life policies is that they accumulate cash value. Bottom line, he was paying $16,000 for a $1 million second to die policy. When we took that and put it into a second to die universal guaranteed policy, we were able to take that same $16,000, but instead of having a $1 million death benefit, we were able to increase the death benefit to $2 million and guaranteed it to age 97. Oh, and by the way, we were also able to not only double their coverage, but we also added the most important long-term care insurance coverage so that the individual was then able to withdraw money from the death benefit if they needed to be able to pay for any type of long-term unreimbursed, for any type of long-term care expenses. How do we take an asset, a premium bill, and turn it into an asset? Male age 96 had an $800,000 universal policy. $26,000 was his current premium. He was basically running on fumes. He had no cash value left. Currently, that coverage would have lasted another year to age 87. $29,000 premium was required, and it was going to be increasing by 5% each year. I advised the client that there's an option called the life settlement. We looked into it. We did what's known as a life expectancy report, which again is one of the most important things, according to Marty Schenkman, is that everybody should have a life expectancy report to get a better idea of what the insurer looks like, not just on the outside, but on the inside. We obtained a life settlement offer, and the client accepted a $220,000 life settlement cash offer instead of facing a $29,000 premium that was going to be increasing by 5% each and every year. When it's not done correctly, well, there are just a significant number of lawsuits. I'm not going to go into them now because I simply don't have the time, but breach of trust by the trustee, breach of trust. On the other hand, Stewart Cochran versus Key Bank showed that when a process was in place, that it protected the trustee, even if the trustee made a erroneous decision or a decision which in fact hurt the client. But there was a process in place. Schneider-Finman, first time that a court allowed a beneficiary to have standing and to be able to sue the estate trustee, the estate attorney. Moving along. Life insurance, as Matt mentioned, is a very useful asset, whether it's owned individually or whether it's owned in a trust. The Secure Act, well, as Cy mentioned, the Secure Act removes the stretchability and that the benefit now must be paid out within a 10-year period. So we have male 25 inherits $1 million. Under the old rule, his life expectancy was 57 years, and he would have had to have taken out $17,480 a year. Under the new secure law, where he now has to take out the money over a 10-year period, there's a significant increase in taxes. Under the old rule, he would have only had to withdraw $4,000. Under the new rule, with that same 24% bracket, he's now going to take out $24,000. Bottom line is that there's an additional $20,000 times 10 years. That's $200,000 per $1 million. That's a significant amount of additional future tax liability that the beneficiaries and oftentimes the insured or the trustees are completely unaware of. A better strategy would be to design a policy with a guaranteed universal that maximizes the death benefit, use a second to die policy because it is the least expensive death benefit, and it's the most efficient way to pay future estate taxes. Using an IRA to pay estate taxes, well, again, it's nothing special about the idea of using the RMDs to buy life insurance to pay estate taxes, but it is one of the most significant, most efficient, effective ways of paying for one's estate taxes. When you use IRAs, you have several problems. They're taxable, both income taxes as well as it includes the value for estate taxes. But when you use life insurance, the RMDs are used to buy a tax-free death benefit, which is outside of the estate. The value is guaranteed, unlike the quote 401 turning into a 201. The death benefit provides a guaranteed death benefit, guaranteed leverage, and because it's a second to die policy, the coverage is less expensive. We know that estate taxes are going up, and that sunset provision could take place before 2025. Well, with estate taxes going down, the possibility of stepped-up basis may be disappearing. Estate taxes will increase for many, and a better way to pay the estate taxes, again, is to use a guaranteed universal life insurance policy, which maximizes the death benefit, and more importantly, a second to die policy, because the estate taxes, as we know, are due and payable at the death of the second spouse. Again, guaranteed universal life policies benefits, as I mentioned, they provide a guaranteed maximum death benefit. They're guaranteed, and they're best used to pay for future estate taxes, as well as the IRA beneficiaries' future income tax liability. The benefit of a second to die policy is that because it pays at the second death, the cost is significantly less. Let me give you an example. Cost of $500,000 guaranteed to age 96 for male 78 is $31,000. For female 74 is $18,000. But when you combine them both, husband and wife, and you have a second to die, the cost for both is $14,700. Fourth item, living benefits of life insurance. Life insurance is an asset class, and as such, has various benefits that many people are unfamiliar with. One is that it can be used to pay for qualified long-term care expenses. That is a huge benefit. Secondly, they can be used to supplement retirement income, either for a business owner or for an executive. Thirdly, they can go ahead and be used as a life settlement, as we said a moment ago, turn a bill into an asset. Using life insurance to pay for long-term care costs, life insurance today can benefit the insured by having the death benefit, by having the benefit for the, having the costs for long-term care come directly from the death benefit of the policy, tax-free. And if the benefits aren't used to pay for those long-term care costs, then the beneficiaries get the tax benefits. Majority of policies issued today have that long-term care rider. Being able to use a life insurance policy to supplement retirement on a totally discretionary basis. Give you an example, a male 45 deposits $25,000 a year to age 65. That initial death benefit purchases $1.67 million of death benefit. Income at age 67 from that $25,000 deposit for 20 years provides a $77,000 supplemental income. And the death benefit at age 82 is still over $250,000. These benefits are used for supplemental executive retirement plans or SORPs for supplemental owners retirement plans. And as we just mentioned a moment ago, turning a life insurance bill into a life insurance payout. Individual had a $3.5 million policy, had approximately $1.2 million in cash value. However, when we did the life settlement, we were able to increase that cash value from 1.2 million over to 1,875,000, simply because the insured wanted to provide money to his children while he was still alive, rather than waiting until after he'd passed. A lot of the information that I just mentioned is in this particular book. It's still in print, and more than happy to provide a discount to anyone who's interested in it. I'd like to thank you, and I'd like to go back to any questions for either Cy, for Matt, or myself. Thank you.
Thank you. Thank you very much, everybody. That was a great presentation. I know we did go over a little bit. If anyone does have any questions, please put them in the Q&A now. Or if any questions come up, you can email us or the speakers. And I think that was an incredible amount of information in a very short period of time.
Barry, I just would like to mention that, and on my end, again, we're all here as resources, and you can certainly email each and every one of us. I also had some handouts. Again, if anyone would like, there are two current articles, one from the New York State Bar Association, the other from Bloomberg's, and they're current articles regarding much of the information that I just went over.
Thank you. Thank you very much. I want to thank you all and thank you all for bearing with us, but I think it was worth the extra time to get all that information. Have a good day, everybody.
Thank you very much, Barry.
Thank you.